To remind the court, on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated the chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Laposata's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Laposata resigned. In addition, it was promoted that in the station nightclub fire, Dr. Laposata had a heroic effort, and in her testimony she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours, directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino. And in Patino, after testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Laposata gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. Laposata for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticism she received for her handling or lack of handling of the station nightclub fire, and finally get into the credibility, adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case, so I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all, Mr. Brennan said that the audit established that a as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. Laposata put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. Laposata herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the Station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it, based partially on the Tompkins case.
Right, and I don't know anything about the Patino case, and what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. Laposata personally no fewer than 4 or 5 times. Maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, It's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay. So the first two, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those two areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those two will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well.
I will.
Okay?
Has a copy.
Okay, so,
I didn't know that. I appreciate that.
all right.
You want to do any other thing? I don't know if you want to handle it now or after lunch or later, but I want to address the issue of the 3 persons.
Okay, so let's mark those now.
Sure.
Can we mark them all as one A, B, C?
I have no preference one way or the other. It's just 3. They're all
Mr. Jackson, if you can I just see it over here?
Of course.
Just hold up the size. ID, yeah.
Yeah, it would be, yeah. Just to mark them.
You know what, show me that one again too, please.
Exhibits H, quadruple H, and I, through I.
All right. All right. Mr. Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right. And what's the objection to them coming in through Dr. Laposata?
it's not part of her report or opinion. She's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices. It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate to these, I'm sure Dr. Wentz will utilize them if stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could because he certainly used them in his analysis and opinion. But I should be subject to the entry of evidence in the defense case in chief. I understand I can use it in Dr. Rachler's testimony. testimony, but I want to use them with Dr. Laposata. She's a medical doctor.
What do you?
Consider them for purposes of her opinion. I cannot understand.
So what do you want to ask her about them?
Are these the X-rays that you reviewed? Yes, that's it. That's
Okay.
it.
Okay. So go ahead.
That's all I was going to ask. I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, you see the X-rays that we talked about a little bit earlier. Yes. This is the right hand. Yes. That's the arm. The forearm. Yes. That's the upper arm.
All right. So they're cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right. So the last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint, so I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other witnesses.
All right, so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6. So what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yeah.
I
Please.
didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know we're talking about action now. We went through, based on Mr. Brennan's suggestions last night, and significantly edited the entire thing. Literally every single slide that you had a problem with. There were a couple that we just literally left, but it is very, very.
I see that a lot of the hearsay has been removed.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right.
It made streamlines.
So what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now. So 9 through 27,
Slides 9 through 27 or pages?
slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on. Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler or no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process. The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasion to compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one,
You could live with what?
number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it. 24. The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this
No.
slide?
No. No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32, I think, is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion. 33. Again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number 1, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34. I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinematics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving a opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34. And number 3, I don't have a problem with. The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Renshaw to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success. Number 1 and 2, I think, are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54. Again, number 1 gets into his opinions. Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56. I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are improper, 2 not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. If these are Dr. Renshaw's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3. And number 4 is ultimately an opinion that he's self-endorsing. 66. Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in a slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate. 68, I don't think Dr. Welcher's report was introduced. And putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report, I understand that, but putting in a random page from a report as hearsay should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72. I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74, again, it's a conclusory opinion, it's bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on the board to self-endorse shouldn't be permitted. And those are my objections.
Okay. Ms. Little?
Thank you, Your Honor. First of all, there is something if I stand here only because I'd like to be able to reference the PowerPoint.
Yeah, that's fine.
Thank you, I appreciate that. First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that were filed by the Commonwealth. We did delete a large section to try to accommodate some of their concerns, as well as shorten some of the opinions. So those were the only changes. I just wanted to make clear to the court. There are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of the slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears and clothing.
So this is a direct test. His testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in abuse.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying the proper foundation for him.
All right, so we can come back to the fabric argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. Rentschler is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't do these on slides is because we objected to Dr. Wilkins coming in on his PowerPoint.
So I looked at that yesterday.
Copy of this specific opinion that was placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on one second. Is it a conclusion page?
I don't know.
Hold on.
But it's page 136. It's entitled Evidence Read Lexis Iconology. And it states the totality of the evidence is consistent with the right rear corner of the base 2021 Lexus impacting the argument. And Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that.
So that is different than what I said he could be asked on his ultimate question, right? But it still came in? Was there, I'm sorry?
Yes, that came in over the defense.
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said, and Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
It's an 80-page PowerPoint.
Okay.
This is solely to make sure that this goes efficiently and effectively. I think it's helpful for these. We've narrowed down the text on the slide significantly. It's important to see those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than 1:15. All right, the jury is coming over. I just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in 3 because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar.
Thank you.
All right. And also, I had a chance to look at the actual exhibit regarding what came into evidence from Dr. Welcher and Ms. Little. Contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So that PowerPoint did not come in. I had a chance to look at Dr. Rentschler's PowerPoint, and at least for now, maybe you can persuade me otherwise, any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury. So before Dr. Rentschler testifies, those slides that were objected to that have text are out.
Can I have a moment just to examine the Dr. Welcher PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Okay, because we have 4 copies of the PowerPoint, and I know that I'd like to be able to. 137 is the report. So,
Mr. Alessi, please. (136), 137, and 138 are all blacked out. All right, the jurors on their way, right?